Hello, hello. Good afternoon, everybody. Welcome. Today, we are going to talk about the trustee's job. My name is Francisco Sirvent. If we haven't met before, I think I've met some of you before. And I am the founder of Keystone Law Firm and Lifestyle Planning, where we we take everything off your plate that we can. Specifically today, we're going to talk about what the job is of a trustee who is doing the job that you've assigned to them if you can't do the stuff yourself. This is a big job, and so we're going to go through as much of it as we can now, help you get a little bit better perspective on what it is you're handing over, because sometimes we just don't know. Before we dive in, though, I do want to just point out to everybody, we've got more upcoming webinars with more topics posted on our website, keystonelawfirm.com/events. They're free to attend, like this one is. You're welcome to go there, sign up. You're welcome to send it to somebody if you think somebody should know about one of those topics. We also do record these and put them on our YouTube channel, so you can catch them again. If I move through something too quickly and you want to hear it again, you can go listen at youtube.com/Keystone Law Firm, and you can see all of our prior topics there as well. These are intended to be about 30, 45 minutes long with some time for questions. So you can go get a lot of details there about all of what we do. And speaking of questions, I'm happy to take questions. You can send them in by chat. Just type them right in there and I'll get to them as I see them. And towards the end, I'll open it up and allow you guys to unmute yourself if you want to do live Q&A. Happy to do that. I just want to warn you that because this is recorded and will be posted publicly, please don't share anything that you wouldn't want known out there in the public domain. So if you have a very specific question about your situation that you want to keep private, I'll give you the information on how to schedule a quick call with me or my partner, Michelle, or Alexis, who can help triage what those questions are if you'd like to have a private conversation about it. Before we dive in, as any good lawyer should know, we have to do all the disclaimers first. All of that lovely little text there basically comes down to a few things. First, this is general information of an educational nature. This is not specific legal, tax, or financial advice for your specific situation. If you need specific advice, please seek that from a qualified professional. So your successor trustee. Arizona law has a whole section of code. It's called the Arizona Trust Code that spells out what the duties of a trustee are. And those specific duties are there so that there's no question what the trustee is supposed to do. Because a trustee, by definition, is not taking care of their own money or property. Now, you might have a trust in place. If you have a living trust in place right now, you are the trustee of your living trust. I promise. That's typically how that's set up. The difference between that and what I'm talking about here is because a revocable living trust, while you are the trustee, you're the primary beneficiary, or you and your spouse if you're married. And most importantly, second most importantly, is that you can make changes to the trust anytime you want. So you're allowed to scrap it and throw it away. You're allowed to change the terms. You're allowed to pull all your money out of it. You're allowed to do whatever you want with it. So all the legal duties that we're talking about today, they're not imposed on you when you're just acting as your own trustee for your own trust, okay? If you created the trust and you're the trustee and you're the beneficiary, you can basically do whatever you want because it's your money. What we're going to talk about today is what happens when it transitions to the next person in line. And that might be your spouse, and some duties do apply there. But it also certainly applies when it transitions to somebody who's not your spouse, because at that point, all these legal duties kick in. And the reality is I come across a lot of people who are doing the job of a successor trustee, and they came for advice too late. Part of my job, I actually do handle some litigation cases around that stuff after somebody has passed away and somebody's been acting as successor trustee. And a lot of times we see that the person who was named is not quite doing the job right. We had one, and a lot of times we're helping them clean it up, get it done right, fix whatever needed to be fixed. But a very, very simple one was not that long ago, and the successor trustee just kind of sat on things and didn't really do much. And then everybody else is getting grumpy and upset and like, what's going on? We're trying to be nice. We're trying to be nice. And it just kind of went on and on and on and on and on for over 5 years. So yeah, the duties that we're going to talk about today, they require you to act in a timely manner. You have to be reasonable about the steps you take. You can't just sit on your hands. You have to take the steps that are required of you. So the trustee juggles all of this. They are ultimately legally responsible for what happens with the trust assets. The main reason is that they are in charge of money or property that isn't their own. Okay. It is for the benefit of others. Now, they might be one of the beneficiaries, but if there's other beneficiaries as well, then they're legally responsible for managing it for the benefit of the others. And so that's why there's a lot of duties about how they do their job, because most of life we manage money for ourselves. If I make a mistake with something, I'm not going to sue myself, right? I just chalk that up to a learning lesson. But when you're managing money or property for someone else, they have the right to hold the trustee personally liable out of the trustee's pocket, personal money, if mistakes are made. So you want to make sure you know what this job is when you're handing it off to somebody, when you're designating that, or if you're named as a successor trustee in somebody's documents, so that you don't make those mistakes. The last thing you want to do is take on this job, get to the end, make all the distributions, and then somebody sues you for doing something wrong, even if it wasn't intentionally, or even if it was by accident, or gosh, I didn't know. None of those things are defenses. They're not. The trustee would have to pull into their own pocket and pay the trust back, or the beneficiaries back, for what was done incorrectly. A lot to juggle. I'm going to cover as much as I can, and I welcome questions as we go. Let me just make sure I've got my question section open. Perfect. And so what we're really talking about, not in that first stage while the grantor, that's you, is alive. We're not talking about this today. Okay. That's setting up your trust. That's keeping it up to date as life goes on. That's making sure it's got your wishes spelled correctly. You've got everything funded to your trust correctly. There's a whole bunch of other topics in that stage. What we're talking about here is everything that happens to the right of that, in that next section. So a successor trustee's job gets triggered by one or two events. If the trust maker becomes incapacitated, or if they pass away. Either one of those is a trigger in most trusts to transfer authority to the successor trustee. How does the incapacity one get decided? It's usually decided by you, the trust maker, the grantor. It's decided by your treating physician. So if you're in the hospital, it's going to be the hospital doctor. If you have some long-term care illness, it's going to be by the doctor that's treating you. And they just need to prepare a letter that says, so-and-so can no longer manage your financial affairs. And generally that's sufficient. And then the trustee prepares their own documents to take over control of the trust. That's how it gets triggered, I think, incapacity. And then at death, of course, somebody passes away and you have a death certificate. That's the starting point. And we're going to talk about that date as being a very important date to the successor trustee for a number of reasons. So I want to point this out for you. If all you walk away from today is knowing that that date is a very critical date, you will have learned something really, really valuable that I see a lot of attorneys miss this point. So that date that the trustee's authority is triggered is a very important date. So from that date forward, there are a number of steps that the trustee has to do. I mean, I have a book called My Trustee's Manual that we offer for sale. And it's 130 pages of the information that a trustee needs to know to do the job correctly. We're not going to go through the whole thing today, obviously, but we're going to cover what we can. The reason it can get confusing is we see this happen when there's a family member who is the successor trustee and they are also one of the beneficiaries. The reason it can get confusing is because the trustee, the successor trustee, is the bad guy in a lot of circumstances. They're the one who has to say, no, we have to do it this way. No, we can't speed it up because we have to do things like this. No, I can't do that because of this. There are a lot of competing interests that are going to bear down on the successor trustee. And, like you see on the screen, it can be anything from just family conflict among the beneficiaries. There's 3 kids, 2 of them want the house. There's 4 heirs, and 2 or 3 people want that one piece of art or mom's wedding ring or whatever. There can be family conflict, and they are the ones that has to stay very neutral. They have to stay objective. They can't think about their own interests in that stuff. They have to defer to the others. And so that's tough. They have to figure out where all the assets are. If there's distressed assets, digital assets, they got to figure all that stuff out. And of course, if they're a family member, they're going through the challenges of grief at the same time they're trying to be professional and do the job and sort through somebody else's life. And that's tough, right? So there's just a lot of competing interests they have to balance. In a lot of ways, they have to make sure the trust is taken care of even ahead of their own life. If their life gets busy, if their life gets chaotic, their own personal life, and they just focus over there and they let the trust linger and linger and linger, they're breaking their duties. They're breaking the law. They have to take care of the trust as the priority. And so all those competing interests, it's going to be stressful. It's going to be exhausting. There's going to be late nights where they had to do something for themselves, and now they still have stuff to do for the trust. It has to be done. They have to make it a priority. So we always watch out for that. What are the golden rules? These are the golden rules. So there are more than 4, but these are the biggest 4 that can encompass the whole thing in one way or another. These are legally spelled out in Arizona law. The trustee has these 4 golden rule duties. The duty of loyalty, okay? Duty of loyalty means that they are loyal to the beneficiaries. They're watching out. They're not making their own needs, their own desires from the trust more important than anybody else's. They can't say, well, I'm going to move into mom and dad's house while the trust is being administered, and then take 3 years to finish. That's not fair. They can't say they're going to take care of the trust, but then completely ignore it while they take care of their own personal business. They have to be loyal to the trust. Okay. The second one is duty of impartiality. As the trustee, when you have multiple beneficiaries, you can't favor any one of them over the other. You can't. You have to treat them all in accordance with the trust document, with whatever interest each one of them gets. So you have to be completely impartial. The trustee, even if they didn't like that one person, they have to treat them with just as much dignity and respect as everybody else. They have to be completely impartial. We had a case last year where a trustee was very clearly favoring one beneficiary over the other 3. And it got so bad, we had to file a lawsuit against the trustee. get them removed. I mean, it happens, and it was all based on misinformation and just basically had developed a bias that, well, these three are just moochers and that one's the golden child. And that's not fair. That's not what the trust documents allow. Now, it doesn't mean that a trustee can't take information and use information, but they have to be impartial between all the beneficiaries. A trustee in Arizona is obligated to follow the prudent investor rule, which is incredibly complex when you get down into the nitty-gritty of it. But the basic idea is that whatever the assets are when the trust is handed over to the successor trustee, okay, so maybe there's a house, there's some investments, there's some stocks and bonds and rental property or whatever. Like, there's going to be a mixture of different things. The trustee has a fresh new duty to evaluate if that's appropriate based on the trust. It might have been appropriate while mom or dad was alive because that was their money. They were deciding what to do, their prerogative. Once you become a successor trustee or somebody else does, they cannot rely on that reasoning to just leave things as they are. That's not a justifiable reason. The prudent investor rule says you must manage the assets like a professional. So if mom had, 50% of the trust, her biggest investment account was stock she got from her company, and I'm just going to make up a number. Say she has $500,000 in her Honeywell stock, and then she's got her house and some money in savings and stuff. And she loved that Honeywell stock and she believed in the company and she wanted to keep it. The trustee doesn't have the ability to just say, well, that's what mom wanted, I'm going to leave it in there. That is a highly concentrated position that is very risky. If Honeywell takes a dump, all of that takes a dump. So the trustee has a duty to look at it and say, do I need to re-diversify this, right? Do I need to just make this safer? Do I need to make it more diverse? What do I need to do? I can't just leave it as is because that's what mom or dad did. You have to follow the prudent investor rule. If you don't, and there's loss from that, the trustee is personally liable from that. And then the last duty, which is one of, I think, the most important duties, is the duty to inform and account to the beneficiaries. So because the successor trustee is the person who, they're the ones whose name's on the check. They're the ones whose name is on the investment account, whose name is on the title of the house, their name is on the title of all the things. So they can buy, sell, whatever, right? They have the authority to do that. But they're doing it for the benefit of the beneficiaries. So everything they do, they need to inform the beneficiaries about it. And they have to be prepared to give detailed accounting of everything they've done, every transaction. They have the obligation to inform them. And even sometimes inform the beneficiaries before you take a big action. Hey, some of you have said maybe you do want the house, maybe you don't. We haven't got clear indication. I'm telling you, I'm intending to put the house up for sale for this price with this real estate agent. If I don't get any objections, I'm moving forward. If I do, blah, blah, blah. Those sorts of pre-informations, here's what I'm planning to do, can sometimes save a trustee's butt big time. So duty to inform, and then the duty to account usually comes up towards the end as we're getting ready to make distributions, where you want to be able to show exactly why there's this much left. These are the 4 golden rules that we want every successor trustee to follow. And when we end up in litigation, because they didn't do one of these things, these are the ones we go after. And it just happens. The most common ones, duty to inform and account, and the duty of impartiality. Those are very frequently, a trustee very frequently falls below the standard of care on those. So watch out for those. As the successor trustee, you're taking over sort of the financial life of somebody else, okay? One of the first things that you want to do is categorize everything that you know of. So there's going to be bank accounts, real estate, investments, IRAs, life insurance, cars, rental properties, businesses. There's all these variety of things. In the first category are things that are passing by a beneficiary designation or have some kind of joint ownership with right of survivorship, because those things are going directly to that person. They are actually not trust assets. Okay. So even if you say in the trust, I want my Chase checking account number, blah, 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 to go to so and so, if that Chase checking account was owned jointly between the individual and somebody else, the trustee has no authority to go get it and transfer it. It's not a trust asset. So categorize those things in that first category. And the last category are things that were in the decedent's name and had no beneficiary. We see this on real estate all the time. I just talked to an attorney from another state who has a probate happening over there, and they just discovered there's property here in Arizona that is in the decedent's name. There's no beneficiary deed. There's no joint owner. It's just the person's name, and they passed away. Those are assets considered in the probate estate. Might be a bank account, might be stock accounts, could be a savings bonds, it could be all kinds of things. Those are in the category of the person's probate estate. Those, depending on the value, Arizona law allows for some flexibility on which level of probate you might need, but depending on the value of that category, that'll tell you what level of probate is needed to be able to administer those assets. And then you have to determine, is there a will or is there not, and go through all that. And then finally, in the category for the successor trustee are things that are titled to the trust. And again, it could be any of these things. It could be bank accounts, investments, real estate, cars, could be all kinds of things. That as the successor trustee, those are the ones you are responsible for. Period. You are responsible for those, and that's what you're managing under the terms of the trust. Sometimes in that category all the way to the right, you'll find that the decedent had a will that said, hey, when I pass, if there's anything in my estate, put it in my trust. Okay, well, then it'll come to the trust eventually. Then you'll be responsible for it. But until it does, it's only those things that are in the name of the trust. And on that point, it's happened more than a few times where somebody passes away and they've got a bank account here and a Schwab account there and real estate over there, and they've used different names of their trust, some varieties. You want to be very careful and use a very consistent naming convention across everything. If you come across something like that and it's your trust, get it fixed. If you are successor trustee for somebody and you come across something like that, it's going to take some extra legal work to figure out. It may require a court order to instruct and direct what's supposed to happen. Or in fact, there might be a separate trust with different instructions, might have a different successor trustee. We've seen that. So look at that trust name very carefully, make sure it matches the trust you have, and then you can know what you're responsible for. All right, so what does the first 30 days look like for a successor trustee? There's more to it than just this slide, but just to give you the big hitting points, that first 30 days is where a lot of the legwork is done. You know, it's going to take about 20 hours a week in most circumstances to just dig in, gather information, learn what the heck is going on, and do what you need to do. Okay. So first, it's making sure you go to the house or you go somewhere and you look for the important documents. You know, you're looking for the will, you're looking for the trust, you're looking for any financial statements, bank statements, deeds, business documents. You're looking for all of those important documents. You're making sure they're secure. You're making sure the house is secure. Probably change the locks. That you don't know who they gave keys to. And so it's your responsibility if the house is in the trust to secure that asset. So changing the locks is a prudent thing to do. It's very simple and it doesn't cost that much, so it's worth doing because then stuff doesn't disappear. You might also need to put in a camera system or an alarm system if you're not there regularly to check on it. Because again, you don't know who has a key. And even if you change the keys, you want to make sure people aren't realizing there's a vacant house and they're breaking in and snooping around. And then you want to secure as much of their digital life as you can. If you can access their email, that can be a very good source of information. A lot of banks and other places send out their statements only by email now. And if that's what the decedent chose, then you're going to need to see the email and say, oh my gosh, there's something from Chase Bank. I didn't know. Oh, there's something from Fidelity. What's at Fidelity? It's just going to give you more information of things that you can gather. Digital assets can spread pretty far and wide pretty quickly. You might be looking for social media accounts. You might be looking for photo accounts, if they stored their stuff on Amazon Photo or all kinds of things that you might not want to lose. And so you're starting to investigate that stuff. The second week is when usually you're ordering death certificates. Most of the time, my standard recommendation is order 10 and go from there. If you know there's lots and lots of bank and investments and real estate, there's just lots all over the place, you might just order 20 to 30 of them. If you think, gosh, they had one bank account, one house, and one car, do you need 10? Probably not. Should you order less? Up to you. 10, I think right now they're about $20. So $200. It's harder to order them later if you need more. I'd rather you have extras and be able to get the job done without having to wait to order them. So that's kind of typically what we recommend. And then you're going to start notifying other people, right? This person passed away and I'm now the trustee and you need to know they've passed. And so you might be calling their bank, their financial advisor, their CPA, any investment companies that they worked with, Schwab, Fidelity, Vanguard, Edward Jones, whoever. And that's all you're really doing. Credit cards, annuities, pensions, Social Security, Medicare. There's just a lot of places to call and tell them, this person passed away. Here's my name. Here's my number. Here's my mailing address. And that's all you're doing. You're just reporting the death. Now, if somebody has, if you become a successor trustee because somebody is incapacitated, you're still going to be doing that. You're just going to be telling them something different. Hey, this person's become incapacitated and I'm their successor trustee. Most of the time, you're also going to be their power of attorney. And so you can say both and they'll tell you what they need. You'll say, here's my name, my contact info. I'll send you whatever you need. And then you go from there because you're going to need to be securing all of those things as well. Get out to week 3 and you're going to continue with your notifications. You're going to probably start getting some things in the mail from the banks or the investment companies or annuities or pensions or whoever. And they're going to start asking for stuff. Those letters that they send are usually going to say, we're sorry for your loss. Here's what we need from you. And it's going to give you a list of documents they need and probably a form to fill out. You're just going to collect them and start processing them and sending them back. And that's going to just be an iterative process. You're going to continue that until everything seems like it's done. We have one where the gentleman passed away 3 years ago, and we are at the end of the probate process, and we just got something in the mail we've never heard about before. Go figure, right? Okay, we got to deal with it. So you're just going to be doing that over and over and over again until you see there's nothing left. You're going to want to review the terms of the trust and the will if they have it. A lot of these legal documents have pages and pages of boilerplate. What you're really looking for in those documents are who is named as the successor trustee, hopefully it's you, and who are the beneficiaries, who gets stuff, right? That's the key parts you're going to be looking at immediately. You might be sitting down, if you sit down with a lawyer to review it, they'll most likely look over all of the boilerplate legalese stuff to make sure that it complies with best practices under Arizona law or tax strategies and things like that. And obviously they'll flag for you anything that needs to be done to preserve any tax strategies or asset protection strategies so that the beneficiaries get the best result possible. And then week 4, you're starting to think about creating that initial inventory. That initial inventory is the beginning asset list. And the beginning asset list is that date I mentioned. It's either the date of death or it's the date of incapacity that you're going to be looking back to. So think about this, it starts there, right? It starts over here. You start doing the job way over here, but it's not until, 3-4 weeks later that you start creating that list. I mean, you can start creating it anytime, but you want to get to the point where you have a list that shows what was there back here, okay? So you are looking backwards and creating that list. So you might be, if somebody passed away on March 1st, here we are, end of April, we would already have all the March statements in the mail or the first quarter statements for brokerage accounts. We can look back and say, okay, on March 1st, see, here's the March statement. This bank account had this much, brokerage had this much, whatever, right? And you can look back and say, as of March 1st, here's what there was. So I'll show you an example of that in a little bit, but that beginning list is going to be your foundation, your starting point. Everything's going to go from that. It's going to be built on that. Don't wait to create that just because there's something out there and you need to get more information and you can't find it yet. And so I'm not going to fill that out until I get this last piece. Don't do that. Fill it out, create your list, and just make a line, just put on one line, something at Fidelity ? Fine, you don't know yet. So be it. 3 months later, 6 months later, you find out about it, you update the list. That's all it is, okay? So that's your first 30 days. You're really putting your head down, you're figuring the stuff out, you're digging into the details, you're gathering the mails, you're making sure bills are being collected, and if there's urgent bills that need to be paid, you're securing access to a trust account to pay those bills. All those things are that first 30 days. It's kind of a sprint, but it's where you get just all that first input of information to be able to do the job correctly. What happens in the next 6 months? Next 6 months, it's not as crunched in one little time period. It's much more spread out. One of the reasons it's spread out is because we have to wait for a certain statute of limitations to go by. So you get to spread it out because there's not the urgency of, we got to make sure the utilities are on. We got to make sure, right, it's okay. We've done all that emergency work. Now we're just in the administration period. And we have to wait for this statute of limitations to go by before we can distribute anyway. So there's not as much time crunch. So you're finishing up that inventory and valuation as of the date of death or the date of incapacity. And you're going to create a document that lists everything out. If you need to get real estate appraised, businesses appraised, personal property appraised, you should be arranging for all of those. And your list should be in a way that it's sufficiently describable. Chase checking account ending in 1234. Schwab brokerage account ending in XYZB. You want those to be identifiable so that if somebody needed to pick this up without ever talking to you again, they could literally go, I need to call Schwab, I need to call Chase, or whatever. If there's life insurance that's coming to the trust, you put life insurance, say it's that Prudential policy ending in 1234. Okay, you put all those things on there. Vehicle, a 2020 Chevy Malibu. Do you need to put a value on it? Yeah, see if you can get a Kelly Blue Book value. If you don't, then you just put a placeholder question mark, because you don't know yet. But get that inventory to the point where it's got everything you do know on it, and you're going to send it to all of the trust beneficiaries at that point. Okay, they're entitled to know what you know as the successor trustee. Remember, you have the duty to inform. Within that duty is the duty to be transparent. So if you find out there's a whole lot more money than you thought, you can't keep it a secret. Okay, if it's in the trust, it belongs to all of the beneficiaries. So your job is to inform them and say, here's what I know of so far. In the middle of there, you're going to be collecting the bills and reviewing. You can get a free copy of their credit report, and you're just reviewing all of that to see what's out there. Were there credit card bills, were there mortgages, were there lines of credit, were there vehicle loans, medical bills. Did I say that? There's all kinds of things that might be out there. And then in the mail, you're just getting the mail. And as you see things, you're just kind of creating that file. These are all the bills. And what should realistically happen is, again, you're creating another list of them because you want to share that with the beneficiaries. Hey, here's all the bills that I know about, just so you know, right? That's helpful because you're at some point probably gonna have to pay those. And when there's a reduction in the value of the whole trust, you'll have already warned them that that's going to happen. We've had many cases where nobody knew, except the decedent, that there was a big outstanding tax bill. They were kind of hiding it. And after somebody passes, you find out there's a $50,000, $100,000, $200,000 tax bill. It stinks, but yeah, you want to let everybody know as soon as you know. That's kind of the best practice is when you learn something significant as successor trustee, you want to very quickly tell everybody. And then you're starting to think about and plan ahead for tax returns. Every person who passes away has the same obligation to file their last tax return as they did if they were alive. Just because they're dead doesn't mean their last tax return goes away. It still has to be filed. And most of the time, it's on the duty of the successor trustee to do that. If there's a personal representative appointed under a probate estate for that decedent, then the personal representative usually takes the lead on that. Most of the time, it's the same person sitting in both of those roles. So you want to start planning for that, making sure you have a CPA or other tax preparer who can help you file that last tax return for the decedent. But also, you need to start thinking about filing whether or not the trust is going to need a tax return next year, or the probate estate will need a tax return next year. And sometimes you won't know that until next year. But start thinking about that, because if you know you're going to need one, then you want to just be able to prepare your file for it so it's not a big nightmare when you have to file it. And then you want to ask your CPA if they've ever done a 1041. It's a fiduciary tax return. It's what trusts file. It's what estates file. It is different than an individual tax return. And so make sure it's just somebody who's done that. All of that is going to take you about 6 months. Somewhere towards, on the prior slide, there is a filing made that is called a notice to creditors. And it's a legal document that's published that says, hey, anybody out there, this person has passed away, and I'm administering the estate and the trust. If anybody out there has a claim against the estate, this is your only chance to do it. You have 4 months from that, when that was published, to file that claim, or you forever lose your right to do so. So that's done in the last slide. So we get to the end of that period on this slide, and that tells us that even if there was a valid bill, if it wasn't sent in that 4-month window, there's no liability. The trust or the estate doesn't have to pay it because they didn't follow the rules. So when we get past that date, whatever we've collected beforehand, we're now done. We now know what the total list of bills are. We don't have to wonder if anything else is going to come in, because even if it does, it's not valid. Okay. So that's why we do that. That cuts off the statute of limitations. And then you can move forward with starting to plan distributions. That's going to happen in the next few months. It might take 3 months, it might take 6 months, it might take 9 months. It's going to be dependent on when that final tax return is able to be filed, but you're confirming all the debts and expenses have been paid. You're confirming now, what are we going to distribute and to who? You might, by that point, you might have just completely liquidated all the assets. The house was sold, the brokerage was sold, we got the life insurance, the cash, and it's all in one bank account. And now we just have cash in bank account. Easy. You get this much, and you get this much, and you get this much. It might be different. Somebody might want the car as part of their share, the house as part of their share, and all these things that make it more complicated. So you have to figure out how to offset for that stuff. Or you may have made some small distributions along the way, and so you have to kind of reduce and adjust for those. So you got to confirm all of that. And once you've confirmed all of that, you need to get approval before you send checks. So don't send them checks until you get all their written approval. They agree this is all they get. Okay. If you don't get that from all the beneficiaries, then in Arizona, the successor trustee can get that approval from the court, file it in court, go through the court process. The judge calls for objections, and if nobody has the, strength to stand up and say, I object, it's wrong because of this reason, then the judge will review it and say it's approved, and then you're good to go. Once you get that approval, you're now making those final distributions, confirming they're received by the appropriate people, and then you're filing your notice of trust closure. Sometimes between these two steps, you're distributing, 90% of the assets or everything, and you're holding back, say, 10 grand or something, just in case a couple other expenses happen. You may have a little reserve account like that. And you can do that a lot of times if it looks like the only thing we have to do is wait until April to file the tax return, and we can get everything else out and done now. Sometimes you can do that. But then once it's all done and that last reserve amount is gone, everything's gone, then you do your notice of trust closure and your job is done. And with all of those steps done correctly, you can't be held liable because you've done it correctly leading up to there. Now, some trusts are ongoing. Somebody passes away, they left money in trust for their kids, but the trusts stay, or the money stays in trust for some time, maybe their whole life. All of this still applies, except this last step here will be, this step here, instead of making distributions to the kids, it's distributing to their trust, right? And then the big trust, the original trust is done. Now we have two new trusts, and those go forward on their own path. So that happens frequently as well. This is where I want to spend the last bit of my time. On the trustee's accounting. A trust accounting is a very different way of accounting than what is considered generally accepted accounting principles. It does not follow those guidelines. And so most CPAs, unless they took a specific class on trust accounting, aren't aware of how this is supposed to work. The way it does work, the way it's required under Arizona trust law, and actually this is uniform throughout the states with small nuances, but the general principles are you have your beginning balance, which is the date of death or the date of incapacity. And that's everything listed there. And you do it for a time period. So say you pick a year, okay? So between beginning and ending, you had some money that came into the trust, maybe rental payments, maybe you received some life insurance, whatever. What are those receipts? Well, then you paid money out, maybe towards bills or expenses, or even you made some small distributions ahead of time. Those are disbursements. And then you may have had some of the trust assets, if it were stock or real estate, that increased in value. So what are those gains? And you may have had some assets that lost value. What are those losses? The beginning plus minus needs to equal the ending balance list. And the ending balance and the beginning balance list, those two lists need to reconcile to the bank statements, the brokerage statements, whatever the financial statements are. It needs to be able to tie out to those. So that's the big picture of what a trust accounting looks like and how it should be prepared. And that's what's required in order for a successor trustee to be able to get completely absolved of liability when they finally make all the distributions and they say, I'm done. They have to have been able to show this level of accuracy of the trust activity. It might be a year, it might be 9 months, it might be 5 years, whatever it is, they need to be able to show all of this. We have a case right now where the successor trustee was in charge for 15 years and kept a handwritten list of things, and it's a gigantic mess. It's a gigantic mess. It looks like it's almost going to be impossible to tell really what happened. And in all likelihood, the court is going to slap this person's hand and get them in big trouble. Not just slap a hand, but they're going to end up owing money back. So keeping records way more meticulously than you keep for your own personal life is necessary if you are acting as a successor trustee. Let me look and show you guys what a actual accounting looks like. Give me just a second to pull it up. This is for a trust that was worth about $600,000 or $700,000. It's a fake sample one, but just to show you guys what they need to look like, even if you are not a accountant, then especially you need to hire an accountant to do this for you. So what is this? 18 pages. And this is for a trust. This is just a sample trust, Robert W. Robertson. So they did it, the sample one from January 2011 to December 2011. And we can see in the summary, the way they set it up, where these were all of the pluses and then these were all of the minuses. Okay, so that's page one. Property on hand at beginning of account. This is really what I've been talking to you guys, that beginning date. So valued, they said, as of January 10th. And this is the kind of information you would need. Cash, stocks with their value, bonds with its value, mutual funds with its value, and then here's the total. And you get all of these things from the statement as of the date you have set as the beginning date. So it's going to take you a month or 2 or 3 to get all those statements. But once you get them all, you can now create your property on hand at the beginning of the account. Okay, so there's my initial list. Here we go. Additional property received. Good. So we received more property. This was received on 2/10. Okay, great. Here we have additional receipts. So you can see there's interest on some things. There's dividends that are listed here. There's some more dividends. And then there's the total. Great. Gains. So I talked about gains. So this mutual fund had a gain of $750. This one had a gain of $1,150. All of these things are considered gains and they get recorded on a list there. This one didn't have any business income. Here we have disbursements. All right, the dispersed to the bank, custodian fees, accounting fees, trustee commissions, attorney's fees. And then here's the total, right? All of these were disbursements. We have losses. They didn't have any losses, none. Okay. Net loss from trade or business, there wasn't any. Distributions. Oh, look, we have a distribution to Elaine of some cash. Okay, we got to record those. Property on hand at the close of the account. So then here's what was left. Cash in the bank. We still have stocks. And here's the current value as of the valuation date. So this is the end of that period. Bonds with their value, mutual funds with their value, and the total. And then this was a nice extra sheet, which is estimated market value that gives you the start value and the end value for each thing, which is nice to see because then you can see how things changed over time. So there's the start value, 668, and the end value, 677. Great. Changes in investments. This is just a schedule to show how the value of this mutual fund changed in time. And this is just a log of all these investment changes. Proposed distributions, there wasn't anything there. So this 18-page document is the appropriate form to use for a trust accounting, for one that's about $700,000. If the trust is worth $200,000, you might be a little simpler. If the trust is worth $2 million or $20 million, it's going to be more complicated. It's going to be more detailed. Generally speaking, because this was a sample one, there's not sample statements to attach with it, but you would attach, let me go to that one schedule that says, let's see here. So you see how this is, this one. Estimated market value that shows the starting value and the ending value. Generally speaking, you would attach to this the statement that corresponds to showing this cash, the statement that shows this stock, this Aetna life policy, these mutual funds. You would attach all those statements, and then you would attach these statements, the ending balance, the Advantis money market fund statement, that checking account, this stock, this insurance, you would attach all those ending statements and they would match with that date. That way there's proof to the beneficiaries that you're not just making things up, right? Okay. That was a lot. But that's what I wanted to cover. I went a little bit longer than I expected. Any questions? Any questions? I will let you guys know if you have a trust that is managed by Keystone. We have most likely told you all of this before. I hope this is good recap and reminder and refreshment for you. Our firm does offer to act as a successor trustee, but it's only for clients where we have drafted their trust because we know exactly how they're drafted. So we offer that as a service. It's a paid service, of course, where we can step in at incapacity or after death to help do all of those things. If you want a family member to stay in that role, but you want them to have help, we offer to help them as their attorney, guide them through, make sure they do all the steps correctly. We offer that as a service as well. And our most comprehensive service is one where we help clients manage their investments, act as their attorney on their estate and trust, act as their successor trustee, and just take care of everything from soup to nuts. So you don't have to worry about this ever again. But that is all I had to say. Our very next webinar is coming up next week, and I want to promote it real quick to you all. It is coming up on, let's see. Oh no, the one's the week after, May 7th, a Thursday at noon. And the title is Why Your Perfect Asset Allocation is Still Leaking Money to the IRS. This one is more investment tax strategy related. Carmi Gutman, CFP, will be teaching that one. And this one talks about how optimizing your the location of different types of investments can give you a much bigger tax bill than what you're expecting. Just by putting this over here and this over here can blow up your tax bill. But if you would have swapped them, you would have saved a bunch of taxes. So he's going to talk about that on May 7th. If you want to sign up for that, it's at our website, keystonelawfirm.com/events. And that's May 7th at noon. Come to open your mic up and just ask or send it in the chat. Otherwise, we can wrap up and I can let everybody enjoy the rest of their Friday. Thank you, everybody, for being here. It's my pleasure to see you. You all have a wonderful weekend.